All right. Hello, hello. Good afternoon, ladies and gentlemen. Good afternoon, East Africa, and welcome, welcome, welcome to this very special and unique webinar session that is exploring effective legal writing. And this time, we're not just looking at legal writing, but we are discussing how you can enhance your practice through an effective client communication. And today is a very special day because we host for the first time a very elaborate panel that comprises of distinguished ladies and gentlemen that have set themselves apart from the pack and established themselves in this sphere of legal writing and effective client communication. And now to take us through this session, we have very two eminent session chairs. The first session chair for session one will be Mr. David A. Asiedu, who is an executive and a partner at ENS Ghana. He specializes in commercial dispute resolution and arbitration. David has acted for clients in a variety of industries, including fast-moving consumer goods, media and telecommunications, energy, construction, and publishing. His experience includes commercial litigation, especially relating to employment, general contracts, distributorship agreements, passing off and construction, as well as arbitration in relation to performance guarantees. In addition, David is experienced in telecommunications, media, and technology law, and he has been recognized and recommended by Chambers Global 2024, 2023, 2022, up to about 2015 in dispute resolution. He is also listed as the Legal 500 EMEA from 2021, 2022, 2019, 2018, 2017. If I start introducing David, I'll introduce him until the cows come home. Our second distinguished facilitator is a man whom I have great admiration for. Mr. Philip Karugaba is a partner at ENS Africa in Uganda. His core practice specializes in capital markets, mergers, acquisitions, private equity, energy, project development, infrastructure, construction law, and real estate law. He is recognized and respected by ranking agencies IFLR 1000 and Chambers and Partners as one of the top corporate lawyers in Uganda. Philip supports clients with complex corporate and financial transactions across a broad range of sectors. With over 25 years, Mr. Karugaba has gained an extensive experience in mergers and acquisitions and capital markets, including cross-border listings, private equity, and financing deals. Including drafting laws, rules, and regulations, such as aspects of the Uganda capital market regulations. He's previously served as a lecturer at the Faculty of Law of my alma mater, Makerere University. He's a member of the Uganda Law Society, a distinguished member of the East Africa Law Society, and he serves on a number of board of different companies across the region. Now, gentlemen, I'm really profoundly honored and exceedingly humbled to have you facilitate this session, and I will hand it over to both of you, starting with our panel, session one, that will be chaired by Mr. David Asiedu. Please note that this webinar session is powered by ENS. So, David, over to you.
Thank you, Gabriel. Good afternoon and welcome to today's webinar. My name is David
Good
A.
afternoon to
Asiedu.
you, Council.
Good afternoon, sir. My name is David A. Asiedu. I'm a commercial dispute resolution partner at the Ghana office of ENS. I'll be your moderator or chair for the first of two sessions. Imagine this: a client calls, panicked. Their business is in trouble and they need legal advice ASAP. You steady your voice and say, I have heard you. Let's go over the details. Then, after going over the details, you say, I will review everything tonight and send you guidance first thing in the morning. The client exhales. They are still anxious, but they are reassured somewhat. That night, you put your thoughts together. The facts are tough. Your client's position is weak, but your job isn't just to state the problem. It is to explain it in a way the client can process and act on. By morning, your email is ready, direct but not harsh, precise yet human. You lay out the risks without drowning the client in legalese. You offer real options, not false hope or unnecessary alarm. Most importantly, you leave the client with a clear path forward. Later, the client calls back, calmer now. The panic is gone. They see their position clearly. They know their next steps. And before hanging up, they say, thank you. Thank goodness you're my lawyer. I know what to do now. Wouldn't you like to be that lawyer every single time? That's what today's session is about. Write in a way that's transparent and thoughtful, concise yet complete, and writing that manages expectations upfront so that the clients aren't caught off guard later. We have 4 fantastic panelists who will share their insights on balancing transparency and sensitivity, the art of delivering bad news, crafting clear and concise messages, communicating both positive and negative news with clarity, managing client expectations through proactive communication, setting the stage for both success and challenges, and finally, legal communication strategies, fostering trust and long-term relationships with clients through effective messaging. Before we begin, let me introduce our panelists. Our first panelist is Mr. James Mukasa Sebugeni. James is a senior counsel at SNL Advocates, part of the DLA Piper Africa Group. With 33 years of experience in private practice, he specializes in dispute resolution, real estate, and commercial transactions. Beyond practice, James is passionate about teaching trial advocacy and contributes to strategic planning and business development across various sectors. His deep legal expertise and commitment to mentorship make him a much respected figure in the legal profession. Welcome, James. Welcome, sir. Our next panelist is Miss Kamami Christine Mishira. Kamami is a highly regarded financial markets lawyer with 28 years of experience in Kenya. Before private practice, she led legal teams at the Nairobi Securities Exchange, the Capital Markets Authority, and several investment banks, giving her a 360-degree perspective on financial regulation and transactions. She has played a key role in shaping legal and governance frameworks and has led some of East Africa's most complex and high-value deals. Kamami advises top financial institutions on capital markets, structured finance, fintech, and corporate governance, earning trust for her and her market expertise and client-focused approach. Welcome, Kamami.
Thank you, David.
You're welcome, ma'am. Our next panelist is Miss Edith Michael Mtweve. Edith is a licensed legal consultant and practicing advocate in Tanzania, specializing in telecommunications and fintech law, among others. She was part of the team that drafted Tanzania's model bill for data protection and privacy and has written extensively on the subject, including co-authoring The Role of Data in AI Innovation and Research, which she presented at Strathmore University. Holding a master's in oil and gas law, Edith is also certified in arbitration, mediation, securities, and international law from institutions such as the Chartered Institute of Arbitrators, London, and the Hague Academy of International Law in the Netherlands. Welcome, Edith. Our final panelist.
Thank you.
You're welcome. Our final panelist is Mr. Gabriel Madin Apat. Gabriel is a lawyer at Cush Advocates and Solicitors in South Sudan and a lecturer in commercial law at the University of Juba School of Law. He is admitted to the South Sudan Bar and holds an LLM in International Trade and Investment Law in Africa from the University of Pretoria, South Africa. A strong advocate for human rights, Gabriel has attended multiple specialized courses at the Center for Human Rights at Pretoria. He also serves as Deputy Director at the Law and Development Center, contributing to legal education and reform. Ladies and gentlemen, that's your panel. Now let's get into the discussion. Our first subtopic is balancing transparency. You're welcome, sir. Our first topic or subtopic is balancing transparency and sensitivity, mastering the art of delivering bad news, and it will be taken by James. James, can I start by asking you this? James has prepared a short PowerPoint presentation with which he will use to deal with his subtopic. But if I can just ask you this as an icebreaker, delivering bad news is one of the hardest parts of legal practice. How do you strike a balance between being transparent about the risks while managing the client's emotions and confidence in you? James?
Thank you, David. I know we're not very good on time for the sessions, but the best mode of delivery of bad news, verbal or non-verbal, is to never rush to give your views or opinion. Always have a clear understanding of the goal and objective for which you're trying to make the message or delivery. The balance is in the clarity and the choice of words to deliver the message. That is my view, David.
So can you share a real-life example you come across of when poor communications have made bad news even worse?
What comes to my mind is poor communication made through a third party on your behalf. You're out of the country, and there's a clear, precise misunderstanding of the message, and you're trying to correct it. Reputation, brand are damaged. That's the best I can come up with.
So my next follow-up question, I guess to that you will be able to use your slides to answer. It's about practical strategies. So what are some practical strategies lawyers can use to soften the blow when they are delivering bad news without misleading the client, sir?
My recommendation is always do a situational analysis, whereby you understand the client you're communicating. Remember, that's in relation to the audience you're trying to communicate with. It might be a professional, might be a non-professional, it might be a businessman, it might be somebody who is high net worth individual, but is not educated. So a situational analysis is a very, very key, because then that will determine the strategy you're going to adopt. Will the strategy be better that you do a verbal communication as opposed to a non-verbal? Particularly, imagine if it's a judgment. And I did come up with a a classic example of bad news, which is up for the reading by our participants. You are angry. If I could just spend 30 seconds just to allow the participants to read that.
Sure, sir.
So you are angry. The Supreme Court judgment has come out. You use legalese, legal jargon. And at the end of the day, because of your anger and anxiety and emotions, you end up insulting or being unprofessional and unethical. And you say that the judges nowadays have no brains. This is not a live example, ladies and gentlemen. This is something I conjured up. It has not happened in Uganda or in any country in East Africa. So please don't quote me as having said that this is from any Supreme Court within jurisdiction. That's a disclaimer I'm making on behalf of ELS, ENS, and my own law firm. So, David, you can see
Yes, sir.
the different aspects which come out of that example, which I just came up with. A classic example of bad news.
Yes, sir, I can. And I know you've prepared a deck of slides. So here's where I give you a short while if you would like to run quickly through some highlights of these to further illustrate the point.
Thank you very much, David. The next slide will show you just a few points which I've come up with. I know I have covered many, but I'll just touch 3, which are very important, so that I can save some time for my colleagues since we started late. I've already mentioned, understand the audience you're addressing. Tailor your message and communication and writing to be more receptive, persuasive, and impactful to that audience. Very, very key. The other one is clarity. We sometimes, as lawyers, want to use legal jargon. If you remember in that example which I set out, we talk about stare decisis and some other things which I have mentioned. But is your audience going to understand that? Are you communicating with general counsel, in-house counsel, or a lay client, as we would say? The other thing which I mentioned is the non-verbal and verbal. Remember, in non-verbal expressions transmission, 93% of the communication is through body language, facial expressions, etc. But here we are restricting ourselves to the written communications. So the tone you put in your correspondence and communication is key. And last but not least, remember to remain professional. However angry you are, however disappointed you are, calm down, breathe in, breathe out. Don't always send out your first draft. That is my recommendation. Sometimes it's better to sleep over it. Make the first draft, step away from the computer or from the desk, and go back and maybe look at it in the morning. When you've calmed down, you're less angry. If I was to give the example of that Supreme Court judgment, those would be my recommendations. The other thing which comes to mind, if we could go to the last slide, I'm trying to go through very quickly because of time. Preparation and clarity. I am a gentleman who believes in preparation, preparation, preparation. The more you prepare, the more clear and better the shot will be in whatever you decide to correspond or write about. That applies to a letter, legal opinion, because preparation includes the research, understanding of what you want to talk about. Remember what we said, the strategy. Then some of the things which we always forget as lawyers is being empathetic. The message should be persuasive, impactful, but always have some empathy in it. But last but not least, as lawyers, business is about delivering a solution. Outline the available options and realistically communicate the challenges and the potential outcomes. Give some reassurance to the client about the availability of any solutions which you think are practical and achievable in a smart manner. And if it is possible, after you write, ask for feedback, find out whether the client or whoever you communicated with understood what you actually communicated. So that would be my end to cut on the time we have so that we can catch up. The conclusions are there. Just to recap on the bad news, I try to explain what that word is, which was in the communication. I will be honest with you, I opened the dictionary, law dictionary, which I've owned since I was in first year law school. And I just got that word in the law dictionary and I used it in that communication. So read it. If you have never seen it, have a good laugh. But most importantly is the power of clarity. Power of clarity. Because what not being clear gives you that. This is too much. Please send me a pointed summary. What does that mean? They did not understand you. Thank you very much, David. Let me allow my co-panelists also join in. Thank you very much.
Thank you very much, James. That was clear, short, and sweet. And it brings us to another crucial aspect of legal writing, clarity. Even when the news is good or neutral, if the message isn't clear, clients can still end up confused or misinformed. Kamami will deal with a second subtopic. And Kamami, I know you probably have slides too, but let me start with a general question and you can still speak to your slides. Lawyers often struggle to keep their writing both clear and concise without oversimplifying things. What are the biggest mistakes you see in legal writing that reduce clarity? Kamami?
Thank you very much, David. And no, I do not have slides because I'm trying to avoid death by PowerPoint. So I'm going to be speaking through my points, which are quite a number. So allow me to go through them very quickly.
Yes,
many thanks to my colleague and partner, James, for what I think have been very insightful initial comments. As James observes, law is not really an end in itself. And we start by understanding our client. One of the things that reduces clarity in legal communication is that we lawyers just don't take the time to understand the client holistically, and also to understand the specific instruction that we are dealing with at a point in time. We read and we listen, but we don't take time to understand. And the result of that is that our responses to the clients then tend to be clouded. It's very, very important to begin by what I call preparing the land. You know, even when you're firming, you must prepare the land. And so we must make it our business. Not two banks are alike, not two insurers are alike, not two clients are alike. We also, and these are my initial general comments, tend to apply what I call blunt scalpels. So the doctors, the surgeons use scalpels. We lawyers use language. Language is really our scalpel. And if the scalpel is not sharp, then we run into trouble. You can imagine a surgeon who is working on you with a blunt and rusted tool. I know we like to say that English came on a ship and the ship was very leaky, so that by the time it was getting to the shore, half of it had sort of found its way into the sea. Unfortunately, it is by and large the language of business and the language that we communicate in for many of our jurisdictions. And the points I'm going to talk about, apply equally to whatever other language that we may be using. And it's very important to have good and strong control and understanding of the language, the basic language of communication as a lawyer, to observe and obey the rules of construction, sentence construction, grammar, vocabulary, because these all affect what our clients understand. I know that sometimes, when I speak to the younger lawyers and they think, oh, this is stuff we studied in primary school. Yes, there's a good reason why we studied it and in high school, and why we must continue to understand it and to observe it, because it impacts what it is that our clients understand. So how do we sharpen our scalpel? By reading widely. My partner, William Maima, always tells us that, a person who is not reading is a person who's not learning. And for lawyers, it is just that much more important that we are consistently reading so that we can sharpen our understanding of language. Let me just give a few examples of things that cause us to completely confuse those who we are serving. Precision. Whether we are communicating generally or we are communicating through agreements, because agreements themselves are really an understanding of the minds which the lawyer puts together, an understanding of the client's minds. Precision is so critical. One of the phrases I hear all the time from young lawyers is, we will revert in due course. What does in due course mean, really? To who? Is it so difficult for us to put down, a timeline? We will revert promptly. Promptly. Does promptly mean, again, if we say promptly and within 3 days, that has a different meaning from promptly and within 30 days. The client then gets, a very clear understanding. To your example, David, you can imagine how frustrating it is when that client that calls you really anxious about an event that is likely to wipe away their business gets I have heard you and will revert in due course. It really doesn't work. We are also notorious for misusing terms as lawyers. So we will say, for example, that a party has violated an agreement. Agreements are not violated. Provisions of agreements are breached. Regulations are violated. Regulations are not breached. And again, it's just important to understand. One of my pet peeves is the word severally. As lawyers, you hear lawyers saying that, oh, I called you severally. Severally does not mean I called you a number of times.
Several times.
And the minute I sit across a person who misuses the word severally, then I know I'm in for a rough ride. Let's go to the issues. Simple issues such as spelling. So Philip and I practice in the world of finance, and we often talk about principle. A client will not be impressed when you send them an agreement that has principal spelled L-E and not A-L. The two words have very, very different meanings. Principal with an A-L, with an L-E, is talking about fundamental beliefs and not an amount of money. So when, the client reads that the principal amount is, then you've thrown them before they can understand what it is that you're talking about. Punctuation, commas particularly, are a complete minefield. Commas can really distort and they can add significant risk to your agreement. Let me just give you 2 quick examples. So if you say, let me talk about, first of all, the serial comma. The serial comma is something that many lawyers don't pay attention to. And the serial comma is the comma that comes before and. I don't know where there was a school where we were taught that you take out the comma before and. Taking out that comma has an implication on your communication. So for example, if we say that the fees shall be shared equally between Dan, James, and Kamami, Dan, James, and Kamami. Effectively, what you're saying is that Dan will get 50% of the fees, and James and Kamami will get the balance of the 50% of the fees. However, if you say that the fees shall be shared equally amongst Dan, James, and Kamami, then it is very clear that the intention is that each of James, Dan, and Kamami will get 1/3 of the fees. If you say, for example, an employer will pay 50 million if the contract is terminated within 5 years without commas, and then you rephrase and say, an employer will pay 50 million, if the contract is terminated, within 5 years. Those 2 sentences, again, have completely different meanings. What it means is, in the first one, is that, the employer will pay 50 million irregardless, as long as they do it within 5 years, if this contract is terminated. The second example means that the employer will only pay the 50 million if the contract is terminated before 5 years are up. So some of these simple, English rules can really make a difference to what it is. Remember, our work as lawyers is to translate the intentions of our clients into meaningful provisions that then provide clarity and bind them. And the last thing we want is to have discussions in court when a contract goes bad as to what it is that the parties intended. Let the discussion be as to whether the parties met their obligations or did not meet their obligations, but not what it is that they intended because of poor construction and communication. Apostrophes, they are not surpluses. We need them. So if we say a seller's interests were secure, the seller's interests were secure, without an apostrophe on the S, it's left to one's imagination as to whether you have one seller or you have multiple sellers. When you say the sellers with an apostrophe between the R and the S, and when you say the sellers with the apostrophe coming after the S in the second instance, then you're talking about multiple sellers. In the first instance, you're talking about a single seller. Colons and semicolons are something that we Africans, including those in East Africa, seem to have a battle with. We just refuse to believe that these punctuation marks have any effect or meaning. Again, we need to pay attention to them. A colon, typically, when you want to introduce a list, please use a colon. When you want to separate two ideas more forcefully, then use a semicolon. Hyphens. Hyphens. Hyphens are not things that, again, we liberally place all over. They have an implication. If we say that this was a 2-year contract and we hyphenate 2 and year, what we are saying is that the contract was expected to last 2 years. When we say a 2-year contract without the hyphen, then it's anybody's guess what we are saying. And I'm not sure whether we are suggesting that it is 2 contracts over 2 years or what exactly it is. Again, we are trying to say here. Parentheses, more commonly known as brackets, are much better off left to the mathematicians and not for us lawyers. I advise as much as possible to avoid using parentheses and reconstruct the sentences in a way that they work without the parentheses. If necessary, we use commas. We lawyers like to use adjectives a lot. I like the example that James has just given to us. Ridiculous judgment. Is that necessary? Is the nature of the judgment, does it need a description? You read about unexpected death, and you have to wonder which death is expected, just so that we can know. The lengthy preambles, we can do away with those. Those are not necessary at all. They just show off that, we know a lot of words, but the beauty of effective communication is being exactly what David has said, precise, concise, and ensuring that your message gets across with as little noise as possible. Complex sentence structures. If there are people who can turn a page, forget a paragraph, into a single sentence, it is us lawyers. As much as possible, we should try to simplify. Remember, again, the basic rules. A sentence should contain a single idea and we should try and keep our sentences very short. Otherwise, our clients struggle. By the time they're getting to the end of the paragraph, they have completely lost what it is that we were trying to say at the beginning. James has already alluded to the use of legalese, ex officio, inter alia, mens rea, mutatis mutandis. We are known for the Latin and everything in between. Let's keep the legal jargon and the Latin between us because we find it funny. We had to struggle through it at the university. Our clients, if they were to tell you the truth, they really, really don't enjoy it. And they don't think we are very clever because we do that either. Pronouns, we have to be very careful when we're using pronouns. So we cite the name at the beginning. And when we use the he or she, we must be careful that it is expressly clear the he or she that we are referring to. And my personal preference, much as it sometimes makes the sentences cumbersome, particularly in agreements, is simply to repeat the noun rather than default to the pronoun. As lawyers, we tend to use passive voices and third party. In fact, it's very interesting to hear some lawyers even speak of themselves in third person. I take that back. It's actually frightening to hear people speaking of themselves in third person. Passive discourse is not the best. Again, we should avoid that. I'm going to wrap very quickly, David, with the last few. Inconsistent terminology. If we choose to use the word company, let's use it throughout the agreement. If we choose to use corporation or entity, otherwise, because the way the human mind works, it picks up a concept and carries it. And when we keep changing it, then we confuse the client because they are not able to tell whether we are referring to the same entity or not. Also, when it comes to definitions, let's be clear in our definitions. When it comes to acronyms, let's ensure in the first instance, when we use the acronym, to very carefully spell out and explain what it is that it means. And as much as possible, to take notice of acronyms that are generally used. Sometimes it's quite confusing when you find an acronym that has a use in common parlance, then taking on a completely different meaning when somebody is discussing it in an agreement. As lawyers, again, we tend to be redundant and to use a lot of words that are not necessary. When you read your sentences, if you read through them, a lot of the time I spend reviewing opinions and work is to ask, what really are we saying here? And can we say it almost in the way that we would speak to the person? I don't know what happens to us when we go back and now try and put things into writing. At the end of every communication is a human being, whether it is oral or it is written. And so it's very important for us to keep communication very, very simple. Finally, I'll talk about the lack of a logical flow. We lawyers, for some reason, tend to think chronologically. And so we present our ideas chronologically, even when it does not make sense to do so. The human mind, again, works with logic, grouping of like items together, simplicity, lists, tables. They make it easier for the clients to understand what it is that we are saying, other than finding an idea in the first paragraph, thinking that you've dealt with that item only for it to resurface in some form in a latter paragraph. So yes, David, that's pretty much it from me. I hope I haven't gone through it too quickly. One of my favorite writers, George Bernard Shaw, says that one of the most unfortunate things in this life is for you to think that you have communicated when in actual facts you have not. So what I would encourage lawyers, especially the younger ones, is to always stand outside of themselves when they issue communication. Just stand outside of yourself. James said, write your piece, go away, come back and look at it again. To that, I add, when you look at it the second time, read it as if you're the client, not as if it is you who is issuing the communication. I tell you, sometimes you'll have a good laugh at what it is that you have put down. Thank you very much, David.
Thank you so much,
Kamami.
Kamani.
Thank you.
That was nothing short of a masterclass. And you've spoken to things very dear to my own heart. Can I ask you, so I'm even going to ask a follow-up question that I didn't plan for. Can I ask you to take 1 minute to comment on this issue? Over the years, the easiest way I have found to irritate a young lawyer is to tell them to look after their grammar, and that the very grammar they were taught in primary school and secondary school is a huge part of the building blocks of clear communication. And when you suggest books they can read and all, they are angry. I passed my law school exams and all. Who is this guy? Who is this guy and why is he asking me to look to my grammar? And you've talked about all these things, commas, colons, elegant variation, pronouns, passive voice versus active voice. What advice do you have for young lawyers when it comes to just the effect of just pure grammar on legal writing and clarity?
So you've raised actually an issue that I discuss consistently. As you can imagine, we are now working with the Gen Zs, and it's completely wild. Writing has been one of the biggest casualties of technology and development. Previously you'd have a chance to put pen to paper, and you'd smell the paper and you write the ink and you think about it, and things sort of would just flow. Unfortunately, now it's keyboards and keypads and, God forbid, screens. And I think that if the whole thinking is just completely different, a lot of short messaging, no punctuation. I struggle even with my children who are scientists, who send me things that I can just not make out. What I say to young lawyers is that, unfortunately or fortunately for us, the communication is our tool in trade, while the other youngsters and the others may have the benefit or the opportunity to choose not to communicate effectively. For us, there's absolutely no choice, and there's no two ways about it. And so the sooner that we, if I can use the term, get with the program and do what we need to do to just go back, revisit. There is no shame. Go to the British Council, and I don't hold brief for them. Attend an English for Business Communication course, just to revisit some of these basic rules. What they will do is make life a lot easier for your clients, and in a language that lawyers understand, your clients will pay your fees faster and more happy, if you like. So yes, for the younger ones, there's really no two ways about this, David. We just have to do what we have to do. We've got to sharpen that scalpel.
Thank you so much, Commander. That was brilliant. And even with the clearest and most well-structured writing, as we've learned from first two speakers, legal advice is only as effective as the expectation it sets. This brings us to our third discussion point, which is managing client expectations through proactive communication. And our third panelist would be Edith. Edith, if I may ask you this as a starter, one of the biggest causes of client dissatisfaction isn't necessarily the legal outcome. It is unmet expectations. What should lawyers be doing in their written communication to set realistic expectations from the start? Edith?
Thank you very much, David. So before I answer your question, I would like to give a little example of myself when I was a very junior lawyer. So I was working in this international firm, and I was just emailing clients just through the normal email language that we usually use, and I didn't see a problem with it. I was just emailing clients here and there, responding to partners here and there, and one day one of the partners came to the office and called me aside and told me, "Can we go somewhere out? I would like to talk to you." And you cannot imagine, this partner sat me down for like 20 minutes to just teach me on how to write emails, something that we as lawyers think that we know is just using professional language and you're done. But there are different ways on how to communicate different aspects of different things to different clients and different people. You have to understand how to master that particular art. And so, yes, just as you've pointed out, Mr. David, that sometimes it's not the outcome that is the issue. Sometimes it's the communication that's the issue. right? And so how should we always set realistic expectations from the start when we're dealing with clients? I think the very first and foremost thing that we can do is from the get-go, when we are engaged by clients, you know, when we have those initial meetings, when we have those initial conversations and emails, we start to express in terms of how we're going to deal with that particular matter. We communicate that in terms of the nature of that particular matter, there are certain challenges that could, you know, come about in terms of the nature of that particular matter. We have to be open, we have to be transparent when we're communicating, so that in the long run, the client will not be, you know, setting out themselves for unrealistic expectations. We always have to communicate with the client in terms of the expectations. Another aspect that I would like to give an example that most of the lawyers, I think, fail in this aspect is overpromising and assuring clients. So, for example, in the very beginning, maybe when a client is coming to you with an issue and you tell them that I will deal with this matter within 2 hours or within 1 day, without necessarily going through that particular issue, analyzing it thoroughly, and giving out a really, you know, truthful or a reasonable amount of time that you would actually take to do it. So at the end of the day, you meet the deadline comes and the client communicates, hey, can you send the document? And then you panic, and then you start being unresponsive to the client, which brings another layer of problems again. So I think overpromising and over-assuring clients should be something that we deal with from the get-go. So, for example, when we are, you know, having the client, the client is coming in, we have to set clear expectations very early from the get-go. We have, for example, if you have a certain case, you have to explain and express in terms of the legal processes that could be involved in that particular case. You can express as well as the timelines and the potential outcomes of that particular matter, so that the client can actually understand, okay, this person is telling me that this small matter, which to the client could be a small matter, for example, maybe licensing. A client could think that maybe licensing, they could get their license within the month or something, but there are some licenses that could take even half of a year or a quarter of a year. So you just express to the client the processes involved and everything. And if possible, when in the, you know, letters of engagement or in the agreements, you put forward those processes that are going to be involved in that particular undertaking, so that you can just expressly put it out there to avoid miscommunications, or to avoid the client not actually understanding the things that are actually involved in that particular undertaking. Another thing is to also have active listening to the client, to understand the client's goals as well, so that you can align, so that in the end you can actually meet their expectations. So what are the client's goals when they're engaging you, when you're conversating, whether it be in the engagement letter or through email, however, in whatever form, you have to understand what the client's expectations are, so that you can try to meet them as well. So as the previous speaker was saying, that most of us tend to answer emails very open-ended. I will respond to you promptly. I will get back to you soon. So you have to communicate with the client as well to understand how soon do they need this work? How expeditedly do they need this undertaking to go through? So I think we need to understand the client's goals, and then we have to align them with the actual processes that are involved on the ground, and finally to communicate with that particular client. Another thing that I really like to advise lawyers as well is to setting the stage for success in terms of clearly defining the deliverables that are involved in that particular undertaking. So you clearly, if need be, you can even create a chart. You know, I know some of the law firms would use some charts that they have prepared, some standard charts in terms of any particular matter that would fall through the ambit of that, you know, undertaking. They would put it in that chart to see like the visuals of how they're going to be dealing with the issues. So we create a chart, a checklist, whatever you might want to call it, to better be able to communicate the processes and the timelines and everything. As well as even the outcome. You can even try to although we don't advise this as much, to overassure clients on the outcome, but sometimes you could give some sort of confidence to the client. Of course, it's not a bad thing, but also you have to communicate to the client effectively on the challenges that could be involved in that particular undertaking, the risks, the delays, bureaucracy. You have to communicate that effectively to the client so that the client can actually understand. And then again, when you're communicating the issues, the challenges that you're likely to face when you're dealing with that particular matter, you also have to, be positive, at least offer some sort of solutions that you could, mitigative measures that you could use for those particular risks or potential challenges. Another thing that I would say, would point out is to update clients. Most of us, once we take the client's tasks and we're fully engaged, we actually forget ourselves in terms of, updating the clients regularly in terms of the matter, the developments in that matter, any issues. So we have to cultivate a culture where we're actually constantly, updating our clients, even if you haven't finished, even if you're not at the deadline, you just have to communicate and update the client. So that builds trust, that reduces anxiety, and it actually, sets you up for a good, relationship with the client. So in terms of finally answering your question, Mr. David, yes, indeed. One of the biggest causes of client dissatisfaction is not necessarily the outcome, but unmet expectations. And so the things that I've mentioned, I think, are the things that we can actually use in order to avoid not meeting the client's expectations.
Thank you. Thank you so much, Edith. The second point you made in particular is so spot on with one of the things my first mentor taught me. He said, do not overpromise and underdeliver. Do underpromise and overdeliver. And that was really spot on. Let me just ask you one final question, a follow-up to one of the points you made about email. And the question is, since we are communicating mostly by email these days, can you tell us what you think lawyers can do when writing emails to prevent unnecessary follow-ups or back and forths, or even misunderstandings with expectations, timing for meetings? Because I've seen emails where somebody sends an email across different time zones. Can we have a meeting at 8 p.m.? Not referring to either of the two time zones, not giving the other person comes back and says, no, not good for me. Then the first person comes back, how about 10 p.m.? No, not good for me. What can they do to prevent the back and forth?
Well, as I've just spoken about before, we need to be very clear, and we need to be very, elaborative in the processes involved and the timelines that are involved. If need be, we can set up a chart or a checklist. We can communicate. Usually, I'll speak for my firm. So usually when a client comes to you and they want to engage you on a certain particular matter, maybe let's say mining licensing, right? We would prepare a checklist in terms of the processes involved, from the very first process to the very last process, the timelines involved, the regulators involved, the government fees and the legal fees, right? And so from the very get-go, the client understands that we will have this thing at this time, this thing will be done at this time, at this cost, and who's responsible, the regulator, which regulator is responsible, and which laws are governing that process. I think that's very effective. You have to communicate effectively in terms of everything. And as you're saying, when you're setting up meetings, you have to align it with the client, and you have to have them confirm. You do not just communicate, we'll have a meeting at 10 p.m. You have to let them as well confirm their availability for that particular meeting. And if they have a counter proposal in terms of the times, they can also communicate the same. So I think it all goes back to effective and efficient communication between you and the clients in order to meet their goals, to actually see what they actually expect, and then to also align with your processes and actually frame a strategy which can actually be workable on both ends. So I think, yes, as you say, David, it's very essential to communicate the very nitty-gritty details of everything when you're dealing with a client, because, you know, we want to have a good relationship with clients and to be recommended for other tasks as well.
Thank you. Thank you so much, Edith. Which brings us to our final speaker for this first session, who is going to talk about building trust with clients over the long term. Gabriel, I trust you've been waiting a while to take over the mic. So let me set the ball rolling by asking you this, Gabriel. Trust is the foundation of strong client relationships. What role does legal communication play in building and maintaining that trust over time? Gabriel?
Yes,
Gabriel. Yes, sir.
thank you so much, David,
You're welcome, sir.
and my dear panelists. Thank you so much. Wonderful presentation. To begin with, sorry, I did not share the slides, but I will prepare my presentation and then share it via email.
Thank
In
you.
the course of the week. To begin with, you know, clients, most of them are laymen. They are not lawyers. So they are expecting a lawyer to know everything. So sometimes they become so mad when they hear that they were given wrong advice by a lawyer. They would begin to say, but he's a lawyer. How comes? You know, they actually trust that if you are a lawyer, then you are presumed to know everything, that you know all the laws. So to build the trust and long-term relationship with client through a legal communication is that, number one is that as a lawyer, you have to update your client on the legal matters. Legal matters, take example in Africa and in the least developed countries like South Sudan, for example, where there are so many laws that have not been acted from the time of independence up to now. So you find that the institutions are using circulars to regulate the economy or businesses. So what could be a policy of this year may not be the same next year. So when a client is engaged with a certain law firm, you have to take that task by updating your client. If there is a new law that has been passed, then you communicate it with your client. If there is a decision that is actually changing the laws, like the Supreme Court decision, then you update your client. If there is a new policy that has come in, whether a political matters which has linked with the legal issues, which could affect the client interest, then you have to communicate it with your client. Secondly, you know, sometimes lawyers are very busy, and you have different type of clients. Other clients, they can send you text message. Other clients, they can send an email. Others want to meet you face to face, and others want to call you directly on phone. So for you to have a peace of mind, you have to understand the clients that you are dealing with, and then establish the strategy of communication. If there is an email and you are offline, at least you have automated response. We could say that we receive your email and we'll get back to you. If you are called and you are busy, you say that I will get back to you, and then later on you come and review your messages, your automated messages, and you respond to them. So any communication that you are engaged with the client, text message or WhatsApp, they are all important because they pass the message to the client. So here is one of the key components of strategy, how to proactively communicate with the client. Some clients also, they just want to explain more and more, even if you have understood from the get-go. You know, you don't need to say, no, stop there, I understand. Allow the client to explain, listen actively, because other clients, when they are explaining their problems, they are also observing you, whether you are listening to them or you are dodging, and then they will draw their conclusion in the end,
Correct.
that maybe this lawyer would not manage this matter, or maybe this lawyer is actually knowledgeable. And at some point, if there is a miscommunication, you acknowledge as a lawyer and apologize, and then have a prompt resolution. You resolve it, and then review your schedule, have a feedback with the apologies, and then get a clear explanation to the client. So in most jurisdictions in Africa, when they deal with client, sometimes you find that, take example in South Sudan, most lawyers, they don't specialize. They practice all across, whether energy, whether agriculture sector, whether criminal, civil litigation, banking system. A lawyer will just say that, yes, I practice across all the legal service. We provide legal service. And then later on, a client, he requests a clarity. So as a lawyer, you need not to respond if you are not prepared. You have to tell the client, I will respond to you in writing within this duration, and then get a law. As we know that a good lawyer is the one that knows where to find the law. Write a legal opinion, send it to a client with the clarity, not using the purely legal term, but use terminologies that are understood well by the client. Another thing is that you have to have a progressive report when you are managing clients' issues. You need to update the client. You know, any information that a lawyer gives to a client, they take it like a good news every day, even if it is not a good news. The idea that you have taken time to call the client, update the client, the nature of the case, the legal issues that are involved, and if there is a political issue behind it, you also explain to the client, and then figure a way that there are options. In case this one doesn't work, we have this option. So you will build the trust. The client will have confidence that even if this one does not go through, there are other means. And if there are no other means, then still there is a lawyer that is standing behind them. Another thing is that some law firms, they have different, they have many lawyers that come from different jurisdictions. You know, in Africa, we have a mixed legal system. common law legal system, and then civil laws legal system, and even Sharia and the mix. So a law firm is managing the client and is also handling issues of the lawyers. So when you are communicating with clients, not everybody in the law firm that communicates with client, because what will come out from the firm, the client will take it that this is a legal opinion. Whether the lawyer is a junior lawyer or is a trainee, any message that is given to the client, which you have not verified, the client will take it up seriously. And then later on, it may have a negative impact on the law firm. So when you have, for example, in my law firm, where I have junior lawyers, if there is a communication, a legal communication to client, then I have to verify it. And then later on, send it to the client when I know what is there. Sometimes they will just be excited to deal with the client directly because they feel like also they have become lawyers, so they have that privilege to deal with the client. But at the same time, they may not be aware that there is a responsibility. There is a responsibility on the side of the lawyer. If they mishandle, you will not have an excuse that maybe this is a junior lawyer. So when you are communicating with client, you don't use everybody in the firm to communicate on behalf of the law firm. Lastly, is that some clients may not be within the jurisdictions that you are in. They may be outside, and they get news. They get news about certain issues that may affect the businesses. Like, take example, you people are in East Africa and in West Africa. You may have business people that are conducting businesses here in South Sudan, and then you hear that the government of South Sudan just walked up and then says that all foreign investors are not allowed to transfer their money in hard currency outside the country because of economic crisis. So when you get news there, you will be eager even at night to know what is happening. You ask your lawyer, what is happening? So for you to build the trust and then effective communication, you have so many options. Use visual, Zoom. You can also use a WhatsApp group with the clients with the same interests. You put them in a WhatsApp group or in a mailing list so that when you are communicating a particular matter, then you pass it to all of them once. Regarding dealing with legal fees, for example, in South Sudan, we don't have a unified legal fees charged by the lawyers. So when you are communicating with the client by giving the quotation, for instance, registration of company or dealing with establishment of the businesses, the same law firm must have a standard that is across the board, so that if one of the lawyers is asked by a client, then the communication will not be different from what the other lawyer is saying. Yes, there may be differences with other law firms, but a particular charge has to be designated for that law firm if there is no a standard rate, so that when the invoice is given, and
Sorry,
then
Gabriel.
tomorrow they ask you, Yes.
Sorry, I'm really sorry. Please forgive me for interrupting, but we have to round up this session. We seriously overshot that time. Sorry. So if we can round up.
Yes. I've actually finished. So what I was trying to say is that in communication, one law firm must have a standard charges when you have not unified the legal fees in that country, so that one communication, different communication from different lawyers in one law firm, they have to conform with one. This can build the client's confidence. Thank you so much. And if there are questions, we will be ready to answer them.
Thank you so much, Gabriel, for your presentation, for your great presentation on trust, from which I took the following highlights, among others: responsiveness, patience with the client, authenticity with your area of practice, a progressive viewpoint, and standard billing. We've covered a lot in this session: how to deliver bad news without losing trust, how to write clearly without losing precision, how to manage client expectations through proactive communication, and how to build trust with the client over the long term. If there is one key takeaway, it's this: the way we write isn't just about what we say. It's about what the client understands, how they feel, and how they respond. Strong writing builds trust, prevents confusion, and saves time. A few extra minutes crafting a clear message makes all the difference. Thank you very much to our panelists, James, Kamani, Edith, and Gabriel, for your valuable insights. We will hand over to the next panel and take questions after their session. Thank you.
Thank you.
Thank you so much.
Thank you very much. Thank you very much, David, and your panel. That was very, very excellent, very, very good. And there were lots of responses from the audience. We are going to catch up on the time. I am going to make some adjustments to the program, and I'm going to start by introducing Aslam Mosaji from the Republic of South Africa. He is a partner in ENS Africa in the dispute resolution team. He's ranked in all leading guides for over the last 10 years. He's a member of the International Court of Arbitration. He holds degrees from Durban, University of Durban, Westville, and University of Wits. I think that's how it's pronounced. Yes?
Yes.
And he is the most prolific writer in ENS Africa that I know. I'm going to put you a bit on the spot, Aslam. A judgment came out last Friday. It's 200 pages long. It's an important judgment. It's from the Supreme Court. You were not counsel in the case. You didn't know the case was pending, yet you have to write and tell your people. How do you manage this? Thank you, Aslam.
So it has to be a team effort, Philip. I think we all work with juniors in our teams. And I think it's also a great career development process for juniors. So you get a junior to do the first consideration of the judgment. You then independently skim through the judgment, take out relevant themes from the judgment, and get the junior to assist you in then summarizing where the judgment ended up in relation to those relevant themes. And once the junior's produced the draft, you then work with the junior in finalizing that draft, making sure it's accurate, and getting the information out as quickly as possible. I think it's important that if you want to be a thought leader, you must be prepared to do the hard work. And the hard work contributes not only to you knowing of the latest developments in the law, but you automatically then are perceived to be an expert in an area of law if you regularly write about cases in that particular area of the law. But you also need to be mindful when writing. You need to be asking the question, will what I'm writing about be of interest to ordinary members of the public. I've also listened carefully to what Advocate Gabriel had to say, and I have to reiterate that it's important to write in plain English and to avoid using legalese. You want ordinary members of the public to be interested in what you write about and to be able to understand what you write about. If we rely too heavily on Latin terms or legalese, the ordinary members of the public then lose interest in your article and don't get as much benefit as they ought to be getting from the article. The other important thing about trying to be a thought leader is that, firstly, it helps build your individual profile, which is important to be successful in the profession. I've pointed out already that you automatically then perceive to be an expert in a particular area. In addition, it gives your firm more exposure, and it helps both you and your firm to recruit more clients and to attract more interesting work for yourself and other members of your firm. You also may get lucky that from time to time your writing is quoted by a judge in a judgment with approval, and that also is a great marketing opportunity for you, and again creates the impression that you are an expert in a particular field. The other advantage of publishing regularly is that you end up becoming a source for younger colleagues to rely upon. And they start engaging with your articles, they start considering the judgments, and from time to time you will get queries that look at a judgment from a different angle, and it may help you amplify your views or do another article in order to deal with the case from a different angle that you perhaps may not have considered previously. I think that's as much as I need to cover, conscious of the fact that we are running out of time, Philip. But if there are any specific questions, I'm happy to take them.
Thank you very much, Aslam. I think you've given us very, very valuable gems there, and we are grateful for your time. We will catch the comments and see how to feed back to the group so that we can catch up on the time for the rest of the panelists. Thank you very much. I will now introduce the rest of the panelists. I will start with Karo Bayanga, who is from Uganda. Aslam is from South Africa. Did I forget to say that? Yes. So Karo is from Uganda. She's an editor and media consultant. She has 20 years experience. She spent time with the Daily Monitor in Uganda, which is part of the Nation Media Group, and she provides training in writing. And I have been one of her students. So if I do anything right, please give her the credit. If I do anything wrong, the blame is mine entirely. Mr. Francis Kamlegia is a senior finance professional of over 30 years standing with PricewaterhouseCoopers. He spent 12 years as managing partner, 8 years on the Africa Governance Board for PwC. He retired in 2022. He's engaged in social enterprise, including a special school for the deaf. And he has written over 200 articles, and he serves on the board of several companies, including MTN Uganda. Next panelist is Isabel Afu-Mensah from Ghana, but sitting in Kigali. She's dual qualified in England and Ghana. She's multilingual. There's a hyphen between multi and lingual. So I think Kamami will explain to us what that will mean. Okay. She speaks French, French, German, Spanish, and English. Okay, those are 4 languages. She has worked in Europe, Africa, and Asia.
She's the executive director of SETA Foundation, a legal foundation and think tank in Kigali. Those are the panelists. I am going to put Mr. Kamlegea, Francis, on the spot first. I'll tell you something about Francis. He is Ugandan. He was writing in Uganda. And for all the writing he did in his tax space, he never once was called opposition. Even when he embarrassed the government badly over some paraffin tax that they had to reverse because he wrote, I don't know how many, 500 words? They never once mistook him for opposition, which is a far cry from other people when they write. So Francis, how do you do this? Over to you.
Oh, thank you very much, Philip, and good afternoon, members. How do I do that? I think most importantly, you have to have credibility. So you don't start off by writing that article criticizing the state and then you think you'll get away with it. So there was a very, very solid track record of consistently being impartial and sharing knowledge and informing different stakeholders from different walks of life of what policy means to the lay person. And I like what we've had in the first session because there was so much emphasis on clarity, on communication, on trust, on credibility, clear writing. And I am not a lawyer, so you're not going to hear any messes or esteemed or much obliged or whatever it is that you really take pride in. But I take pride in simplicity. I'm a very, very simple person, and I communicate with the objective of getting a message across, as opposed to showing the complexity of the knowledge that I have. And just to tell you how simple I do things, I've coined, there's a book called The Pyramid Principle. It's by Barbara Minto. And David, where we started this seminar, he kind of alluded to it in a way. So Barbara talks about 4 Ps. As a professional and a consultant, the starting point is to understand where your client sits or stands. That is position. And once you have to listen, because at times we're so clever and knowledgeable, we want to start talking immediately. You have to listen. And listening requires you to be silent. It's an anagram. Listening and silent are the same letters. The moment you listen, then you are able to appreciate the second P, which is the problem, because somebody comes to you with a challenge or problem. And because you're a professional, you are then able to assess the potential possibilities to solve that problem. And then ultimately, you make a recommendation, which is a proposal. Now, I like that methodology because I always use it when I'm structuring my articles. And then the other one, which I'll just share and leave it at that for now, Philip, is what I call the 4 I's. Letter I, as in indigo. Accountants, lawyers, engineers, doctors, we're technical people and we take pride in the information we know. But actually, nobody cares how much you know until they know that actually you care. Most importantly, nobody, when it comes to thought leadership, nobody cares how much information you have and you know and what credentials you have until you're in a position to share it in a manner that is informative, that is insightful, that is clear and impactful. So 4 I's. As a lawyer, think about all the information that you have, all the stuff that you've read, all those things that you know and you fear to share because you don't want to share it until somebody is paying you for it. But that information is not for hoarding. It is for sharing. Now, when you share information, as a technical person, you have to be in a position to share it in a manner that is insightful. Philip, that's the second I. So information should be used to draw insights. And then those insights, I serve on a number of boards now. I'm always looking for somebody coming to present to me with the information and ask, so what? You should be able to tell me that this then gives these insights as far as our business is concerned, because it's those insights that are going to influence me, Philip. That's the third I. Because you as a professional, your objective is to influence the client, having shared the information and the insights, so that that client can make a decision which is going to have the right impact in their business. And that's the fourth. So information is not just for holding, it's for sharing. not sharing it in a 400-page memo, but in a manner that is insightful, that is very clear, that has clarity and is contextual. And then not sharing it just for the sake of sharing, but trying to influence the client to make the right decision. And that decision should have the right impact in their business, and they'll pay you for it. Let me just finish off with one very interesting situation. It was the 2018 tax policy on mobile money, and when the government introduced it first time, and it came from above, and everybody came back in the budget, and they were so excited about it, and they thought that they are hammering the telcos. And I wrote a piece which was actually telling the powers that be that we have changed from taxing income, and we're now taxing movement of money. And it was very, very simple, because I said if somebody has 1,000 shillings, they earned 1,500 somewhere, and then government took off 30% as tax, and then now they have 1,000. So now when they send their 1,000 to grandmother, wherever, government is saying that when you send, you take tax. When you withdraw, you take tax. When you spend, you take tax. So taxed when you earn, taxed when you save, taxed when you spend, and taxed when you remit. That got above very, very, to use my French, really cheesed off. And he wrote a piece rebutting mine. And I wrote another piece explaining that actually what he was saying was not correct. And then I got a call from somewhere saying that I'm making people look not so clever. So I stopped. And that's the only one time I ever sort of got guided to stop writing. Thanks, Philip.
Thank you very much, Francis. Thank you very much. That is really, really insightful. As always, you've recommended books to read. I remember you introduced me to Audible and gave me a good starter book called Grit. Thank you very much. That was insightful. And when you talked about listen and be silent, I felt convicted in my heart. And I'll tell you a story of how I was called into a client meeting by another partner, an associate, I think, at the time. And I was told, I need some support in this meeting. And this is Uganda. This is a rich businessman. And for whatever reason, I got it into my head that he was illiterate. So after spending 10 minutes trying to speak in another language, not my own, to explain what a debenture was, and he looking at me intently, he asked me in English, he said, "So you mean a debenture?" Do you think I reverted to English, or did I continue my attempt at poorly speaking another language? Any hands on guessing there? Right. Okay. So for our next speaker, I'll go to Carol. Okay. Carol Bayanga, and I've already introduced her. Carol, in preparation for this, we've had you read some of the lawyer's work. I would like you to tell us what you think. I would like you to tell us what we can take home from you as an editor. Thank you very much, Carol. Thank you.
All right. Thank you very much, Philip. It's a pleasure to be here among all these members of the law community. Exciting to be able to share my thoughts. So, yes, I have read a number of the articles that you asked me to read, and I had a couple of thoughts coming through. These articles I assumed were for the general public, not just for the lawyers as well to read and understand, but for the general public to understand, what does this case mean? What does this ruling mean? So I gathered a few insights from, these are a few insights I thought I would share first, is that there were some that were really interesting. And like the previous speaker, Francis, has said, they were very simple, really does a lot of things. It just makes it easier for the reader to understand you, even if what you're explaining is complex. So I found that some of them were, quite simple enough to make me understand, because I'm not for example, as knowledgeable as you people here on the law. But when I read some of them, I thought, oh, this is what this means. Aha, so this is how it affects me as a person. This is how, this is what it means for me if I'm going to go into this kind of, business, or if this is what it means for me if I'm going to do this kind of thing. So I found some of them to be very simple. There were some which was good. There were some also that made it a joy to read, in terms of using metaphors, in terms of using examples. Someone is talking about an issue, they want to, to talk about a particular issue, and then they use an example. They bring a case and then tell us that this is an example to explain what I'm going to talk about. So when you use an example, then it's clear to me. It makes me see, this is the kind of situation a person can be in, and this is how then to deal with it. So I found that to be, really interesting. I found that actually ended up reading the full article, enjoying myself and feeling that I have learned something. I have picked something today. Then there were some, however, that I found to be quite complicated. And I had to read 3-4 times before I could say, what are they talking about? What exactly are they saying? Because maybe the sentences were too long, because like previous speakers have said, there were lots of complex words. And I had to sort of think, what does this mean? Let me go and check what exactly this means, or how is this word used in this context? So I found a bit of that. I also found that some were very important, I would say very important, descriptions of cases, or what those cases or rulings meant. But then it was almost exactly what the ruling had said, exactly what the ruling, was. And so they were not giving me context. This is the ruling, this is therefore what it means. So I didn't have that context. So I thought, okay, so this yes, I know the judge said this. So what does it mean? What does it mean? Is it a good thing? Is it a bad thing? Does it, does it make sense for a person to do this next or not? So I did find a bit of that. So overall, I felt that the content was good. It was helpful, but in some cases it was really simple to read, understandable, even a joy, creatively written. In other cases, a bit complicated, almost a narration of exactly what was written somewhere else. So I'm not seeing the difference, or I'm not giving context into what I'm reading. So I feel like from that, I think my what can I say, what I would like to tell that lawyers who want to write, especially for non-lawyer, can I say, audiences, is to think about those things. If you want the person to be interested in reading it, think about those things. Philip, is this the point where I give my takeaways quickly? Yes, it is. All right. Yeah. So I think the previous panel did this really well. So I'll just really quickly hint on the things that I think that the lawyers can do, especially when you're writing for those of us who are not, in the field, because we don't understand these things. It is important for us to understand what the law says and what it means. So first things first, plan your writing. Plan it. If you're going to write about a case and what it means, if you're going to write about, for the paper, if you want to send an opinion to the paper, you want to write it for your website, plan it before you write it, because then you will understand, you will know the things that you need to put in there. And how do you plan? You think through, how am I going to start this thing? What is going to be in the body? How will I end it? Because that gives you a proper plan of how to put it. And then therefore you won't be wavering between one thing or the other, or you won't be talking about one case and you shift completely to another case and I'm sort of lost. So plan your writing as best as possible. Like has been said, know your audience. Your audience, with your submissions, your audience is probably the judges, the clients, and the client will be forced to know about the law because they're in that space. But if it's Carol who comes across this website, who comes across this article, I have no obligation to read your piece. I really don't. I will read it if it is Philip, who's my friend. But, if not, and then I don't have an obligation. You have to attract me to want to read this piece. Therefore, you have got to try and think like me. What would Carol, who's not a lawyer, what would she understand? What kind of vocabulary would she understand? What kind of information is she interested in? What is trending right now that, would make her want to say, yes, I want to read about this because everyone is talking about it. I want someone to explain it to me. So always think about your audience. Always remember them and say, what would they be interested in? What would they want to read? How would they want to read it? You imagine yourself reading, let's just give an example. A dam, one of the dams, God forbid, in this country. So, something happened and went terribly wrong. And an engineer was trying to explain to us what went wrong. We would hope that he or she would write in a way that we understand and not use complex, physical, terms, terms from physics and things like that. In the same way, Remember your reader, they don't understand complex terms as such, or complex phrases, or lawyer jargon, so make it as, remember them always as you're writing. Thirdly, make sure your writing is good. Make sure it's focused, it's clear, it is simple. Like I've said before, and especially that it is focused. Once you decide I'm writing about this thing, keep the angle that don't keep going from one place to the other, because then we get confused. And then we start to wonder, we were on this case and now we've gone to something else. Or he was talking about this particular issue and now suddenly I feel like he's gone to something else. So keep the piece focused. Fourthly, as has been shared, read. It doesn't have to be only, things to do with the law. It could be fiction, non-fiction, novels, magazines, newspapers. Read, because when you read, you start to see different styles of writing. How people write and how they write, different kinds of ways. Some people have very simple writing, some people have very creative, some are, lengthy but interesting. They're very explanatory. Others are brief, but they're concise. So you pick up different, ideas, and you think, yeah, I can copy this from here. I can copy that. I can try and also, get my own style. So the more you read, the better you get, and learn, take opportunities. I was looking at the list of the attendees, and I saw some people who have been in a class of mine before, from ENS Uganda, Africa, the Uganda team. I saw Anita, I saw Renata, and I was like, that's good, because you keep doing that. They've been to the class, but they're still here trying to get even more information about writing. So keep, whatever chance you get, keep at it, learn, keep, you'll always pick something new. So always keep reading, keep learning. And finally, communicate. All these things are just that you want to communicate. I keep saying in my classes, at the end of the day, you're doing something. You want something. You don't want to just put words on a piece of paper or on the website. You want to convince someone. You want to explain something. You want to inform them so they're well informed, or you want to argue out something so that someone can see your point of view. So you want to communicate one of those things. So if you're writing, you have to do all these things to be able to make sure that you have communicated what you wanted to from the very beginning. Thanks, Philip.
Thank you very much, Carol. That's very, very exciting stuff. You have synced with the previous speakers, and you've gone to emphasize about simplicity, about unpacking the meaning of all these things we do. I want to ask the lawyers out there, maybe there must be a button that you can press here to send emojis and stuff like that. Let's see some hand claps. And then also, I come from a very, very basic community from southwestern Uganda, in which eating meat is very, very important. So this rich member of our community had these lifestyle diseases, and he went for medical treatment, and he was told, I'm sorry, you can't eat meat anymore, which was like telling him, your life is going to be miserable from now on. So he said, so what should I do with all my money if I can't eat meat? Anyway, my point here is that we've spent so much time learning prima facie case, I don't know, bona fide purchaser, what's the other one? What are the other terminologies we learn? Stuff, Latin phrases. And now we're being told, yes, that was for the classroom and for the judge. But when you go out on the street and you're speaking to people, put it behind you. Is this a challenge for us members? Is this something that you can just take off like a shirt and dump it? Is this going to be easy for us, or are we going to have to, what do you call it, forget, unlearn, relearn, and start all over again? Think about it, please. We'll come back to that. Now, my next speaker is Isabel, whom I've kept waiting for quite a bit. And Isabel, of course, my first question for you is, what language are you writing in? Thank you.
English is what I write in.
Good. The floor is yours. 10 minutes. Thank you.
So thank you so much. This has been really insightful, and I hope some of the learnings will be shared with young lawyers. And I love having these sort of sessions because they're so important. Some of these things may come across as basic, but they really are essential to enhance how we do law. So I've been asked to look at how we link our law and our social impact, and a little bit about Certa Foundation. So Certa Foundation was actually set up from a law firm called Certa Law. which is a Rwandan law firm. And the idea behind Certa Foundation was to do a number of things that you could not necessarily do in a law firm, right? So we do a lot of work around professional development. We do a lot of work around the startup community, and we do a lot of work around thought leadership. So that means research, policy advocacy, etc. And I say that it's important because we recognize from the law firm that we had a real passion to do this work, because it's important that we are all holding hands and collectively trying to change the ecosystems in which we operate. So for example, if you have a startup client, 90% of our companies on the continent, whatever country you look at, between 80 to 90% are SMEs. Those SMEs are not going to be paying corporate legal fees, but those SMEs are part of our ecosystem. So what do we do to help grow these sort of businesses? What do you do to help, guide startup founders? What do you do to help vulnerable women or vulnerable children? And so we took that initiative and created a foundation out of it. And I think as lawyers, especially when you look at the digital age that we're in, we really are, and also great for the tax people, but as lawyers, we've got a lot of foundational building, and that we have to start thinking about how we position ourselves in this digital era, right? Because the reality is AI and digital tools are going to do things faster and in some cases better than lawyers can do. And I know for a lot of traditional lawyers, it's a very difficult thing to try to embrace digital and technology, and whether you're using it in the court systems or whether you're using it for research, the reality is that's what's going to happen. But there's an important role for lawyers, and that's because we are taught to be risk managers. I think lawyers are some of the best risk managers on the planet. We're taught to think critically. We're taught to process things because we look at all the different gaps that can happen. And you need people like lawyers with that conditioning to step out into different aspects of society. And so as a young lawyer or as a law firm owner, we need to ask ourselves, what is within our perspective important? And that can differ from person to person. Maybe what's important because of your community or country or just leaning is vulnerable women. Maybe it's waste pickers. Maybe it's the startup community. Whatever it is that you have a leaning towards, there needs to be some allocation of time to support that. And it doesn't need to be a lot of time if more of us were doing that work, right? So if you had a law firm where everybody was given 10 hours a year to do pro bono work within the leaning and the perspective of the law firm, you'd have tremendous change. I think that's the main thing. And we can use, again, because we've got those critical skills, we've got those writing skills, the communication skills. As a young lawyer, you can use those platforms as a way to learn. So we are very big on supporting legal clinics at law schools, for example, because it's a great way to establish leadership. It's a great way to learn how to communicate. It's a great way to learn how to speak to clients, as the earlier panel was talking about, dealing with conflict, dealing with confusion, having to simplify language for clients. Doing something like a law school, going into legal clinics as a young lawyer is not just a waste of time. It's actually helping to refine your legal capacity that you can then use at a bigger stage. Same for law firms. Spending time to do certain work builds the whole capacity of the lawyers. So that's really what I wanted to share. Just, let's use what skills we already have to build capacity, to help smaller NGOs. Maybe they need you to review a document. Maybe you can work on a research project. Maybe you can just take one project and help that startup or that SME develop its, for example, we had an IP issue, an SME, a very young startup, built an incredible tool, but assumed that when he registered with the Rwandan Development Board, which is the Registrar General, immediately assumed that automatically meant that his IP was protected. So that's something even a junior lawyer could write about on your platforms, on your LinkedIn. Spend, have a month, each month, if you're focused on corporate law, write monthly around corporate law issues in a way And I like the previous speaker, what she was saying, Carol, write in a way that is not communicating to your fellow lawyer, but communicating to somebody who chances upon your LinkedIn or even your Twitter, right? But it was very sad, and he lost this project because the software developer he had engaged took the whole project away, right? And we need to build sustainable businesses. We need to support women. We need to support our communities. And you can do that very, very simply with the tools that you already have. So I hope that's helpful. And yeah, that's all on my side, Philip.
Thank you. Thank you very much, Isabel. That's really, really striking a chord with me, and I'm sure with many, many other people listening to you. Again, I'm going to ask for those emoji things. They are very, very colorful in the chat box. Please pile them up, pile them up. Yes, there they go, there they go. Thank you very much. Yes. So I think we're coming close to end of our time. I just want to give, I think it's called shots out to Mr. Dennis Kakembo of Crystal Advocates, who is the most prolific Ugandan writer in my estimate. He's written about everything and anything that I think largely in the tax space. So thank you very much. I had hoped that we would have some time for you to say something, to say why you do it and does it pay? Does it pay? But we've had so many different perspectives today here. I think I can't reduce it to about getting work and money. We've had such an enriching time. So I think at this point, I should hand it back. First, say thank you to all the panelists, okay? And thank you to all the attendees. Thank you, East Africa Law Society. And I will hand back to Angel Gabriel. Someone will ask why I call him Angel, but it should be apparent one of these days. Thank you very much. Thank you all. Thank you all. Gabriel, are you there?
Philip, maybe we should say that there is
Yes.
an icon at, oh.
Yes, Senior Karugaba, I am here.
Yes.
Sorry.
I was handing power back to you, but you know Ugandans
thank you so much.
About to grab it.
All right, so ladies and gentlemen, that brings us to the end of today's very wonderful presentation. And on behalf of the East Africa Law Society and on behalf of the Secretariat, the membership, our CEO would like to send a special vote of thanks to you, our esteemed panelists, for this very wonderful presentation. It's not only been a learning experience, but it's been a moment of reflection to us who often send communication out there. And sometimes we find ourselves making some errors here and there, but it's been really enlightening, encouraging. I'd like to thank you so much, Senior Philip Karugaba, for bringing together these very brilliant minds from across the globe, from the ENS family, from the DLA Piper family. I would like to thank our panelists who are not legal practitioners, but very seasoned thought leaders, people like Ms. Carol Beyanga, Mr. Kamlegea. It's really been profoundly honoring and deeply humbling to learn from you, from your experiences and from your expertise on this subject matter. Mr. David Asiendu and Senior Karugaba, your moderation skills were top notch. I surely had to sit down and take some notes. And to you, our participants, would like to send a very big thank you to all of you for showing up in very large numbers and for filling our inboxes. We'll surely do this again, as many of you have asked us to. We'll sit down with the team and have a second module on how we can do this in a much bigger way. So we want to say thank you. We'll share this recording and we will share any presentations that were relayed so that you can look through them and have a moment to reflect during your free time. Otherwise, from the Secretariat to you, would wish you a very lovely afternoon Please be on the watch out for our upcoming webinar sessions. There's an interesting one on discovering East Africa Law Society. Many of you are members and you do not know what benefits the society has for you. So you want to be on the lookout for that. That session is happening on Monday, 17th of February 2024 at the same time. And then for our young lawyers, if you're ever wondering how to get to the global landscape, we have a very wonderful webinar coming up on the 20th about how you can achieve that milestone by stepping out into the global landscape and thriving. And later on the 25th, we have another webinar that will be discussing abductions and enforced disappearances, which is now becoming a common trend in the East African region. So we really thank you for the support. We look forward to hosting you again, and have yourselves a very lovely afternoon and stay blessed. Goodbye.
Thank you. Goodbye.